Thank you, Mr. Chairman, and thank the witnesses for being here with us this afternoon, especially welcoming one of my former colleagues from the diplomatic team, Ambassador Boyden Gray. Welcome so much, and I'll start with you, Ambassador Gray. Once a Treasury Secretary invokes the orderly liquidation authority for a troubled firm, under Dodd-Frank, the district court can only review 2, I believe, of the 7 determinations made by the Secretary. Is that correct?
That is correct. It can only review whether the firm is a financial firm and whether it is in trouble.
So the other 5 factors of determination are in a way exempt from the court review, and the company has no right to challenge them. Is that correct, sir?
That is correct. When this issue first surfaced in something I wrote, I don't know how long ago now, the Treasury's letter to the Washington Post said there is a huge check in all of this, which is that we must find that this entity poses a threat to the stability of the United States. That finding is specifically excluded from court review.
So if they're unable to challenge those other 5 factors, what types of concerns does this give you over due process?
Well, it is a denial of due process to give someone his or her day in court, and it isn't just that. The Congress is basically cut out. You are basically cut out because what finances this is not required of you. You have no way of monitoring it because the orderly liquidation authority, the Treasury, has its own internal taxing power, effectively, to finance all of this without any oversight by you. So there are multiple problems here, and I think, and you may have another question, but I want to emphasize that problems are accumulating right now. This isn't just a difficulty that's going to arise when and if this kind of a takeover occurs. We're seeing the results of this now as larger institutions get funding advantages based on the implicit bailout of what this provision authorizes, and smaller banks, community banks that really do service local communities like yours, these local smaller banks are having a hard time competing and dealing with the regulation.
And in fact, it codified too big to fail is what is happening.
It codifies too big to fail, and it perpetuates it. And so this is happening today. This is happening today. There's going to be a problem at some point, but right now we have a problem, and it needs to be corrected.
Thank you. Thank you, Ambassador Gray. If I could move on, Professor Merrill, what standard can the court use to review the Secretary's decision that the company is a financial company and that it is in, quote, default or danger of default?
The statute's quite explicitly in saying that the court can only ask whether or not both of those determinations are arbitrary and capricious.
How would an arbitrary and capricious review of the Treasury Secretary's decision differ from a de novo review?
Well, it's hard to say. The arbitrary and capricious language, I think, is borrowed from the Administrative Procedure Act, which refers to arbitrary, capricious, or otherwise not in accordance with law. And so ordinarily when that standard's invoked, the courts have authority to decide questions of law. It's not clear that that Dodd-Frank authorizes the courts to review questions of law. If that's the case, I think it's quite clearly unconstitutional for that reason, among all the other reasons that we've discussed. Under bank receivership law and under the House bill that was rejected by the Conference Committee, the court would have de novo review powers, which means the court would make the record, the parties would submit evidence to the court that they think is relevant, and the court would hear witnesses, and the court would decide all the legal questions independently of what the agency had decided. So
and the determination, I assume, is based on the merit of its argument.
Yes, there's a huge difference between de novo review and arbitrary and capricious, whatever that means, without not in accordance with law being added.
Very quickly, Professor Merrill, how is a court's ability to review the Treasury Secretary's decision to invoke the OLA different from its ability to review the FDIC's decision to resolve a failed bank under the Federal Deposit Insurance Act, for instance?
Well, under the FDIC Act, the court has the power, at the behest of any affected person, to set aside the receivership for any and all reasons and to develop a record and to decide questions independently. Under the Dodd-Frank Act, the court is restricted to reviewing these 2 issues out of 7, and only under this arbitrary and capricious standard, which we don't know quite what that
Thank you,
means, but it
Professor.
sounds very deferential.
I believe my time's expired. Thank you, Mr. Chairman.